California's rent control laws create a maze of protections that every tenant needs to understand. As tenant advocates, we see firsthand how these complex regulations can either shield you from exploitation or leave you vulnerable if you don't know your rights. Two major systems protect you. California operates under two key frameworks. The Costa-Hawkins Act from 1995 sets statewide baseline protections, while local cities like Los Angeles, San Francisco, and Oakland have their own stricter rent control ordinances. Here's what matters. If you live in an older building, typically built before 1979 in LA or 1980 in San Francisco, you likely have stronger protections than newer construction. Your rent increase rights. In rent-controlled units, your landlord cannot arbitrarily jack up your rent. Los Angeles caps increases at 3 to 8% annually, tied to inflation. Oakland limits hikes to around 3% per year. Even outside these cities, California's AB 1482 protects tenants in buildings built before 2005 with a maximum increase of 5% plus the Consumer Price Index, never exceeding 10% total. Eviction protections that matter. This is crucial. Landlords cannot evict you without just cause. Valid reasons include non-payment of rent, lease violations, or legitimate owner move-ins. They cannot evict you simply to raise rent or because they don't like you. In many cities, if they evict for owner occupancy, they must pay substantial relocation assistance, sometimes $7,000 to $20,000. Common tenant traps to avoid. Many tenants don't realize their rights. Single-family homes and condos are often exempt from rent control, but not always from eviction protections. Post-1995 construction typically allows market-rate rent increases between tenants, but ongoing increases may still be capped. When disputes arise, don't fight alone. Cities offer mediation services through rent boards. Los Angeles Housing Department and San Francisco Rent Board provide free dispute resolution. Document everything. Every notice, every communication, every repair request. Critical resources for tenants. Contact your local rent board immediately if facing illegal rent increases. Organizations like Tenants Together and Legal Aid provide free assistance. In Orange County, Riverside, San Diego, and Los Angeles, tenant protection laws vary significantly by city. Your action plan. First, verify your building's rent control status with your city's rent board. Second, document all landlord communications. Third, never ignore eviction notices. You typically have only 5 days to respond. Fourth, seek legal help immediately if facing retaliation for asserting your rights. Remember, landlords bank on tenant ignorance.